Good evening, everyone. This is Wayne Waite. We are here for our February 9 class on civil torts, intentional torts, negligent torts, and basic principles of civil liability. We'll jump right into that right away. And I will share with you what I know about this subject. And you know, the basic principle of civil liability really is this myth of the reasonable, prudent person. You'll hear about this. There's if you ever meet the reasonable, prototypical, reasonable person, let me know. It's what the average reasonable person would find acceptable or what they would do under like or similar circumstances. That's one of the key principles that we'll be talking about tonight as we go through it. And we're always in search of that reasonable man or woman. But tonight we're going to be talking about civil law, a little bit about in criminal as well. But under that, the big buckets of intentional torts are those things which one does intentionally. And then also we're going to be talking about principles of negligence, which hold us accountable for actions, for our actions, regardless of whether we intend harm or not. And then we will be talking about the civil law. And essentially, the goal here is to ensure you have a working knowledge of the kinds of behaviors that you must refrain from in order to avoid civil litigation. So under this whole rubric of civil law, what do we really have? Well, we have torts, intentional and non-intentional torts. We have contract claims, and then there are negligence claims. And tonight we're going to just talk a little bit about each one of those. So let's just kind of go under the civil law section. What is a tort? Well, it's not something you eat for breakfast. It is an act or omission that causes injury to another person by breach of a legal duty, not arising out of a contract, and that subjects the actor to civil damages or to liability for civil damages in a civil lawsuit. And then, as we said, you've got intentional torts and negligent torts. Anything that doesn't have a home under any type of category, if you will, is probably going to be referred to as a tort. So let's start out in our first big category of intentional torts. Now, intentional torts are things that one does on purpose. For example, an assault and battery is an intentional tort. A defamation is an intentional tort. Libel is an intentional tort. Conversion of assets, exerting wrongful dominion and control, is an intentional tort. These are not only acts, but they can also be these are only acts, not omissions. And these intentional torts can also be crimes under federal law or state law or local law. And the example that we have here is the Value Jet 592. Then the state criminal action, that case settled for $500,000 fine. Federal criminal hazardous material transportation act, $2 million in criminal penalties and $9 million in restitution. And then on the civil tort, $262 million to victims' families. Administrative FAA fines worth $2.23 million were settled for $1.785 million. Was it worth it? How can these things kind of come together in a but what I want to do is kind of put up for you a little vignette on that particular case, And you can all be the judge as to whether
1 hour to disaster. A SaberTech driver pulls up at gate G2 at Miami International Airport with ValueJet cargo for flight 592. Inside the boxes are 144 out-of-date oxygen generators loosely packed. A ramp agent places them around a large airplane tire. The pilots are unaware that they have a dangerous load on board. As the plane taxis to the runway, the loose packing and unsecured cargo jolt one of the generators into action. It begins to heat up. 11 minutes to disaster. The plane taxis to its takeoff position. In the hold, the surface of the metal generator gets hotter and hotter. Soon the heat ignites the cardboard box and bubble wrap, and the blaze begins. 10 minutes to disaster. Flight 592 takes off from Miami International. Even though the hold is airtight, the fire is now blazing, sustained by the oxygen produced by the generators. 3.5 minutes to go. The sound heard by the crew is one of the tires in the hold bursting, just as it did in the lab test. Unknown to the pilots, the fire begins to eat away at the systems on board.
We got some kind of electrical problem. The battery charger's kicking in.
The battery charger can't help the stricken jet as the fire is consuming everything in its path, including the control cables that run to the rear of the plane. Captain Kubek begins to lose control of the aircraft. Temperatures in the hold have now reached more than 3,000 degrees Fahrenheit. In the cabin, passengers are becoming desperate as they choke on the toxic fumes. Flight attendant Jennifer Stearns rushes into the cockpit, but the pilots refuse to drop the masks, knowing that oxygen would only make the fire worse. 1 minute from disaster. The cabin floor burns and begins to cave in. 7 seconds to disaster. Now, no one is in control of the plane. The crew is probably unconscious, overcome by toxic fumes given off by the aircraft's interior fittings. Seconds later, Flight 592 nosedives into the Florida Everglades at 500 miles per hour.
So the question then becomes, was those verdicts that I mentioned, were they sufficient?
It took 121 seconds.
Let's see.
A more than 30-year-long, almost spotless safety record, erased within minutes as the Aerospatiale BAC Concorde crashed into a hotel just west of Charles de Gaulle Airport in Paris. But what exactly happened? And
There we go. Sorry. Let's see if we can get back to our PowerPoint here. Yeah. Here we are. So, you know, that particular case, the state criminal, 500, half a million. Feds, a little more, 2 million in criminal penalties, 9 million in restoration. So this restoration in a federal crime is an interesting animal. It's not really a civil judgment. However, in a criminal case, the judge can order restitution, which is like compensating the victims, and in this 9 million restitution is in addition to the 262 million that went to the victims' families. this is a significant case because it's the first time an aviation business was convicted of criminal charges arising out of a commercial jet airliner crash in the United States. Okay, so that is an example of a case where we've got both civil and criminal liability. You can also have a assault and battery. A battery is a harmful or offensive contact, I should say, with another person with the intent to cause or contact or apprehension of contact, so without the consent of the other person. And consent cannot come from fraud or duress. And examples of this in battery can be hitting someone, uninvited sexual conduct, molestation, rape can be type of battery, can be type of assault, attempted battery if missed. So an assault is attempting to hit somebody but missing. I think assault can also be a physical contact, to tell you the truth. So I would disagree a little bit with that definition there. But the next YouTube, I think, is kind of instructive as to what you do not want to see when you are when someone is upset with their pilot. So that is an example of an assault and battery. The next general type of tort that I want to talk about is in the tort of intentional infliction of emotional distress and the intentional tort of false imprisonment. So the intentional infliction of emotional distress only occurs when it is extreme and outrageous conduct so terrible that it causes severe emotional trauma in the victim. And there can be different tests, especially in Ohio, where if you have intentional infliction of emotional stress, you also have to have contemporaneous physical damage. So there's two types of this. There is intentional infliction of emotional stress, also negligent infliction of emotional distress. Generally speaking, there's really no excuse in public aviation for intentionally trying to scare anybody. I mean, the classic fact pattern is that the student pilot keeps repeating the same mistakes. None of us have ever done that. Angering the instructor. None of us have ever done that. I know it's not happy when it happens, but anyway, what if the instructor, in a fit of a temper, reaches and releases the student's seatbelt while rolling the airplane into a very steep and bank toward the student side, grasps the handle of the cabin door beside the student and threatens to expel the student? That's clearly a situation where the elements would be met. Extreme, outrageous conduct, so terrible that it causes severe emotional trauma in the victim. Another one, fixed base operator manager notices an aircraft on the ramp of a person who owes the FBO money. The manager sends a line service attendant out to block the aircraft's departure with a fuel truck and brings the owner into the FBO office. Is that false imprisonment? Is that intentionally confining, restraining, or detaining another person against his or her will? And this doesn't have to be a law enforcement officer, and it can occur when people or businesses use force in an attempt to collect a debt rather than using litigation. Always want to be really, really careful when you more or less take the law into your own hands, when you more or less exercise what we call self-help, because if you do that, you can be liable civilly for damages that result from those actions, either on an emotional distress or false imprisonment. What about false arrest? It's the same thing. False imprisonment carried out by a false or egregious assertion of legal authority to detain another person can be a false arrest. I mean, you don't hear this too much, but generally, a citizen's arrest is limited to felonies, murder, arson, and burglary, and does not extend to misdemeanor, civil, or administrative violations. And when do you know what's a felony? When do you know what's a misdemeanor? Well, you don't. So you really want to be very, very careful if you take on that role of the superhero, get yourself out there and try to stop somebody thinking that you have the authority of law when most likely you don't. And also, it just makes sense, in my view, not to put yourself out there and get yourself killed. So the standard that we have as individuals, of course, is different than that for law enforcement officers. They are protected from false arrest as long as they're acting in good faith, and most likely will have immunity if they're acting in the course and scope of their employment. You know, an example might be a service line attendant in the last example encounters a very large, short-tempered aircraft owner. So instead of stating his or her identity, says, "Freeze, FBI, put your hands behind your head and don't make any fast moves." That is probably, you know, in the gray area. It's not clear to me if the guy who was punching the pilot was involved in a felony. I think he probably was. But you want to be careful when you jump in and try to play a policeman. Well, what about other torts, like the tort of trespass? That's the intentional invasion of somebody else's land without authority or license to be there. And one of the things that often comes up is off-airport landing, or landings in airports not open to the public without permission. And the issue comes up all the time with hot air balloons or cross-country glider flying. And the key here is intent. If you experience a catastrophic engine failure and you pick an open area within gliding distance and land, of course, it's going to be a landing without permission. Most courts will find that you didn't commit trespass because you didn't intentionally invade the landowner's property, but did so in response to an emergency. You know, the key there is to apologize, to take the high road, offer to pay for any damage, notify your insurance company, and the insurance company may pay for damage caused by the landing and recovery crews. You know, this is not the law in all jurisdictions, I should point out, and some courts will hold trespass to be treated as a strict liability defense or a strict liability offense, which means if you trespass onto another's property without permission, then that's an intentional invasion. In Ohio, sometimes the law of trespass with this is what people do to get over this hurdle is if someone is a trespasser on a certain property, they're often issued a no trespass letter, which provides them with notice that you're hereby notified that you are not authorized to be on this property. If you are found on this property, you will be prosecuted and charges brought against you for trespass. And that's to satisfy this condition that the trespass be intentional. That's what's often done. The next tort is for conversion. Conversion is the exercise, the wrongful exercise, I should say, of dominion and control over another's property. So the definition that is here is an act of assuming rights to personal property that are inconsistent with the rights of the owner or person entitled to possession. You know, what could that be? Taking someone's airplane for a joyride without permission. Conversion is close to unauthorized use. That is a lesser offense to a carjacking. It's unauthorized use. Same theft, a lesser included offense to theft is unauthorized use of presence or conversion. So a conversion is really a civil theft. So two options for recovery: money damages for deprivation of the property while it was in the converter's possession, and a court order that the person who took the property, the converter, has bought the aircraft, if it's an aircraft to take, compelling payment of its fair market value. So the law really encourages respect for property rights of others. If an FBO sends an employee down to an aircraft, hooks it up to the tug, pulls it into the FBO's hangar and locks it up until the debt is paid, two conflicting issues could come up. One, the FBO may assert that it has a garageman or a mechanic's lien that allows it to do that under state law. The aircraft owner is going to argue that the aircraft has been converted against the owner's wish, that the FBO has no legal right to hold the aircraft, and that it is being wrongfully held, and that the FBO should pay the full fair market value of the property. Anytime you exert control over somebody else's property, you really want to go slow. You really want to consult counsel, because the last thing you want to do is to find yourself with either a civil lawsuit on your hands, or perhaps even worse yet, a criminal charge for theft. Okay, what about fraudulent misrepresentation? A fraudulent misrepresentation is a representation that's intended to deceive another, or the plaintiff. The plaintiff's person is going to be suing you, with knowledge that the representation is false and with damaging results. So mechanics, inspectors, sellers, or lessors knowingly misrepresenting the airworthiness of an aircraft and defect to a known to that person. So let's say you have a aircraft that is burning excessive amounts of oil, and you tell the folks the engine is clean, no known problems. That's a fraudulent misrepresentation made to an individual. And what do you need in order to line up a fraud case? Well, you need a fraudulent misrepresentation that's knowingly false when made, that's justifiably detrimentally relied upon by the other party, that results in damages to them. So it's not just that you make a fraudulent representation, but all of these key elements must line up in order for that really to have sense, or make to hold water legally. Okay, so now we're into the big area of negligence and liability. This is the bread and butter of what I've done for almost 40 years, I guess. And the most common tort that's involved in aircraft accidents are torts for negligence. And the bottom line, you're responsible for the consequences of your actions. And I think that really is a common theme throughout all of our system of justice. So what's negligence? Well, it's failing to do what a reasonably prudent or careful person would do to protect others from harm, or doing an act which a reasonably careful person would not do under the same or similar circumstances. So a negligence can either be an omission, where you fail to do something that a reasonably prudent person would do under like or similar circumstances, or a commission, where you do something that a reasonably prudent person would not do. And what are the four elements of a negligence case? Well, the first one is a duty. You have to have a duty to be reasonably careful. The second is a breach of that duty, which is a failure to be reasonable careful. The third is approximate cause, and then there's an injury to the fourth. So let's just talk about these a little bit. Let's just say that I go to the hospital, I'm in the hospital, and I am prescribed to have a shot of morphine. Instead of giving me the regular dose of morphine, they give me 2 or 3 times the source of the amount of the morphine. So first question is, was there a duty? Did the doctor and the nurses and the hospital all owe a duty of reasonable care to me not to give me the wrong amount of medication? Yeah, there's a duty. Was there a breach of the duty? Yeah, they're not supposed to give me 3 times the amount of the morphine. Was there a proximate, well, first let's just jump to 4. Was there injury? Was there injury? What if I just smiled and slept better that night? Well, there'd be a duty, there'd be a breach of the duty, but there'd be no resulting injury and therefore not a proximate cause. What if I had a heart attack that night? So there's a duty to give me the right amount of medicine. They failed to give me the right amount of medicine. I had a heart attack that night, but the medical evidence by all the experts proved more likely than not that the amount of morphine that was given had nothing to do with my heart attack. Another case which I had, a real life case, there was a 10 times overdose of a drug called theophylline to a baby in NICU. Of course, the hospital had a duty to be reasonably careful. They failed to do that when they gave the baby 10 times the amount of theophylline. The baby was terribly, terribly injured, but upon further investigation, I was able to demonstrate that the baby had a congenital defect called Angelman syndrome, from which it experienced the birth defects that it had, and it had nothing to do with the overdose of the theophylline. So the theophylline was not the direct and proximate cause of the injury, but rather the child's underlying separate and distinct birth defects. So torts are they're really interesting, but all of those 4 duties have to line up in order there to be civil liability. Okay, this slide really talks more about the duty, failure to use, care, and injury. What's a duty? Well, everyone must be reasonably careful. Duty extends to everyone who could foreseeably suffer harms if you're not careful. Failure to use care, what a reasonably prudent person would do under like or similar circumstances. So back in the medical context, this is what a reasonably prudent physician, nurse, or hospital would do under like or similar circumstances. In the aviation perspective, it's going to be what the reasonably prudent pilot would do, what the reasonably prudent FBO would do, what the reasonably prudent mechanic would do, what the reasonably prudent airport operator would do, what the reasonably prudent dispatcher, air traffic controller, or so forth would do. Injury, it is physical to a person or property, not fear, unless it results in significant medical distress requiring hospitalization. I don't think the hospitalization, I disagree with that, no, but unless it's serious. So, it's clear that a flight crew member, aircraft operator, manufacturer, airport owner, operator, mechanic, inspector, ATC, or any other person, all of these folks owe a duty of care. And who does the duty go to? It goes to people who reasonably rely on them to act reasonably. So it could go to other crew members, passengers, people on the ground, their property, personal property of the aircraft, occupants of other nearby aircraft. And what establishes the breach? Where does the duty come from? Well, it's failure to do what a reasonably prudent person would do. What would a reasonably prudent person do? Well, for example, they'd follow the FARs, they'd follow the airworthiness directives. That would be reasonable. Failure to do that, of course, is an omission, which would be unreasonable. If you but I've said this must cause injury to someone. So if you fail to do a pre-flight check and you take off with an almost empty fuel tank and your engine quits during takeoff and you land without hurting the plane, its occupants or anyone else, you're not going to have a successful negligence case. Now, can you be sued? You certainly can. And oftentimes frivolous cases are sued and are brought. However, generally they will not be, because why are cases filed? They're filed by folks who want to make money on them, lawyers, and by clients So if a lawyer knows that they're not able to prove damages, then they're not very excited in investing in that case because there's not going to be a recovery if there's no injury. So every time when you get scared and you think like, oh my gosh, what have I done? If you've clearly violated a duty, ask yourself what the damages are, and ask yourself, did what you did or didn't do correctly, directly and proximately cause the damages that exist? And if it does not, if there's that causal break, you're likely going to be okay. So, and this is just more on proximate cause. The neglect must have caused the injury, at least by setting in motion a sequence of events that would not have otherwise occurred. So the law can use a but-for test to prove proximate cause. And then we get into this business of, well, what about the NTSB's findings of probable cause? So the NTSB's problem of finding probable cause is not the same as a courthouse, either in the federal building or in the common police court here in Montgomery County. Although the NTSB's conclusion or opinion about whether an act or omission was a probable cause of the crash, the facts, although that's not coming in, the opinion's not coming in, the facts upon which that were found during the investigation are likely to come in subject to the judge. So let's take an example here. General aviation aircraft flying from San Francisco to Denver reports an engine stoppage to air traffic control over the Rockies. The aircraft is substantially damaged, attempting a forced landing, and its occupants are injured. Now, NTSB demonstrates that the time the aircraft took off and the time the engine stopped was reported to ATC. Knowing the standard fuel capacity and burn rate, he suspects fuel exhaustion. Shows up at the scene and doesn't smell any gas, and when he opens the fuel tank, no fuel runs out. He then probes the tank with a dip sip, no fuel. Insurance salvage team comes, starts dismantling the aircraft. He then stands the wings up on end, no fuel comes out. So the NTSB determines the probable cause of the pilot's inadequate flight planning and failure to monitor fuel supply. In that case, the inspector can testify to everything he witnessed. However, an expert will have to be hired to analyze those facts and give their opinion. So, and the reason for that is that the expert can be cross-examined by the folks in the courtroom, and the jury, and when I say folks in the courtroom, I mean the jury or the judge, and they can make a determination as to whether that person is credible and whether their evidence, whether their testimony should be given any weight. When a report just comes in and there's just words on a page written by NTSB, examiner, whoever, and he's not in the courtroom or she's not in the courtroom, you can't cross-examine this piece of paper. And as a result, that's kind of the reason the law takes that type of position. So, proximate cause. More than one person's negligence may be the proximate cause of an accident, and generally, and oftentimes it is. Some states apportion the percentage of negligence among defendants and apportion the damages, and others have joint and several liabilities. So even if there's more than one defendant is found negligent, the plaintiff can collect judgment from any or one of the defendants. So joint and several liability usually leads to recovering the funds from the person with the deepest pockets, and then the co-defendants can fight it out to recover sums from each other. But in the meantime, the plaintiff has been made whole. So let's just say you got a student pilot flying solo and a trainer's practicing touch and go and landings at a tower-controlled airport. ATC notices the student's going to be coming in on final behind a heavy landing jet. ATC fails to warn the student to extend downwind or warn of the possible heavy turbulence from the heavy jet. And the student hits the turbulence, loses control, flips it, crashes the rented trainer. So who is potentially liable in this situation? Well, you guessed it, The pilot, the instructor, ATC could all be found negligent. The student didn't recognize and avoid the turbulence. The instructor didn't teach the student to avoid the turbulence with avoidance techniques. And what about the controller? Hey, he didn't warn them. So they could all be there. So Ohio has a modified joint and several liability statute. It's joint and several to economic damages when the defendant is found to be more than 50% liable, and if not, can only be held for the liable percentage, the amount of this percentage liable. Wages, salary, compensation, expenditures, medical treatment, these are all economic damages. Pain and suffering, loss of life, loss of a limb, heartbreak are not economic damages. And that's the exception there. So if it's over 50%, you can be held liable for all damages. Under 50, only for the amount that you are in fault for. And for non-economic damages, it's proportionate to the amount of damages. What about the case of negligent entrustment? Unfortunately, I did have a airline, or not an airline case, it was a private case where a young man jumped into his father's aircraft and was not in good shape. May have been under the influence of substances, had a friend with him, and they crashed their plane locally. It was so tragic. The question in that case was that was there a negligent entrustment of that aircraft to the son? Did the dad leave keys available so that they could access them? This is similar to the type of cases that you see now quite prevalent about firearms. Are firearms adequately locked, or are they available for folks who shouldn't have them? It can also be the case with automobiles, where you see someone who's plastered and you throw them your keys. You negligently entrust that vehicle to someone who was unqualified and who should not have been allowed to have it. Okay, so now we're into the application courses. So what is a tort? Okay, a tort is an act or omission that causes injury to another person by breach of a legal duty not arising out of contract that subjects the actor liability for damages in civil lawsuit. What's negligence? The negligence is the failure to do or to omit to do that which a reasonable person would do under like or similar circumstances. What are the four elements of negligence? Duty, breach, proximate cause, and injury. Application question number 2. You are the general manager of a fixed-base operation FBO. Your shop performed an annual inspection on a customer's aircraft and released the airplane to the customer when the job was completed, but before your bill was paid. Okay. So they let the aircraft out before it was paid in full. Later, customer complained that the bill was excessive and refused to pay it. Arriving for work one morning, you notice the airplane's parked in one of the airport transient parking spots unattended. The thought occurs to you to tow the airplane into the hangar, lock it up, and refuse to release it until the bill's paid. Is this a prudent course of action? Explain. I don't think so. You release the aircraft, you've given up dominion and control. For you to exert dominion and control over that aircraft after you've done that, I think that is a conversion. There are exceptions to that, but I think it's a bad idea. What's the common theme running through all American law, civil, administrative, and criminal? That's a good question. There are a lot of them. I'm not exactly sure what they're expecting for that, but I think it is compensation, that the law protects property rights and protects to make sure that they are not wrongfully taken without due process of law, and that there is an appropriate remedy when rights are violated. If that is a question on the quiz, we are going to have, I think everybody will give it right, because you probably get it right, because I think that is that's open to debate. Okay, who do you owe a duty to be reasonably careful? Anyone who could be foreseeably harmed, okay, as a pilot. Now, usually we owe only a duty to those who could be foreseeably harmed. So who does a doctor owe a duty to? The patient. Who does a contractor owe a duty to? Usually to the people he is working with. However, the cases, for example, what if you are a demolition expert? Who do you owe a duty to? You owe a duty to those who could be foreseeable and reasonably harmed by your acts or omissions. Okay. And the last one, application question 5. You're involved in an aircraft accident that causes injuries to other people or damage to their property. The NTSB finds that the probable cause of the accident was pilot error on your part. Will the NTSB's finding a probable cause be admissible as evidence in the civil trial against you for negligence to prove the proximate legal cause of the accident? Answer, no, 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 no. Will, so this is, will that finding a probable cause? No. Will other evidence from the NTSB's investigation and report be admissible in evidence in that civil trial? Probably yes. As long as the requirements, I think if that person testifies. If that person does not testify, I would argue that it would be barred by the hearsay rule. So hearsay is generally an out-of-court statement that's offered for the proof of the matter asserted therein. So the investigation report itself is not a statement in the courtroom offered to prove the contents in the report. I think the report is out. The testimony, however, of the investigator, if he comes into what he actually saw with his own personal knowledge. What do you have personal knowledge of? It's your 4-7. It's like, I call it the Rice Krispies witness. It's what you can hear. What can you do with his Rice Krispies? You can look at them, and that's a Rice Krispie. You hear it, you can smell them, you can taste them. Your 4 senses, personal knowledge, that's what comes in. That's what's not hearsay in a courtroom. So with that, that concludes our overview of civil liability with some criminal thrown in. If you have any questions about any of these things, don't hesitate to let me know, and look forward to seeing you in class. Thanks very much.